going on? What's going on, people? We are about to talk about the Etruscans. I'm gonna play one or two more songs, play you guys a couple of, show you guys a couple more of these picks, and we're gonna get into a quick video. This is gonna lead to some of the information on the video I have planned. If you haven't, please go and make sure you put into your notifications for what's coming up Sunday in that portion. So what I'm going to do, I'm going to play this real quick. So yeah, make sure you guys go and do check out that for your notifications for Sunday. It's going to be a good video, going over some really, really good information. I have a book to read and some other things I'm going to get into. So let's continue on for about another 5 minutes or so, and I'll show you some of these picks, and we'll show the rest at the end. All right, let's go. Hold on, y'all gotta hold on. All right, guys. So sorry about that. Peace, peace, and blessings to everybody that came in. Everybody that came in. Stay woke, indigenous. Peace to you, brother. Peace, 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 and blessings. Lajal Bichos. I believe I am pronouncing that correctly, sis. If not, I'm sorry for the botch. We're going to play one more and we're about to get into the bill, guys. I appreciate y'all. Ready? I'm about to play this video for y'all. I wanted to show y'all some things. This is actually a total different um, bit of information, but I just want you guys to see. It was crazy when I played this video. It went right into these. This is about American Magica. We have talked about American Magica when it comes to miscegenation, race blend, and so on and so forth. This is actually going to be another portion or part of the miscegenation. This being a part of American Magica, also a part of alchemy. We're going to be talking about things when it comes to those pathogens, the genomes, all of those things y'all very aware of. So let me put this away right now. We're about to get into this quick little video. I want to show you guys and talk a little bit about the Etruscans. How y'all doing? How y'all doing out there? Realistic, thanks for coming in. Peace, peace, and blessings. And thank you guys so much. I have reached over 1,000 subscribers a little while ago, but I have been blocked. So I don't know if it's showing on your end, but I am appreciative of everyone that is definitely always tuned in, looking to be incited with like information that I don't want to waste your time with. It's generally if you're coming over here is to get some information, not to waste your time or repeat stuff. If it is something that you learned before, that's perfectly fine. It's actually pretty new to me. I've heard people speak of the Etruscans, but I'm not very familiar. I've heard brief information, so actually found the book a couple of weeks ago. I read a little bit. Then it kind of coincided. Actually, I found it because I was into some Roman stuff and some Roman law stuff. And it took me into some information about the Etruscans. And I'm like, who are these people when it came to Rome? And as I searched and did a little research, I found out a bit of stuff about them. And yeah, I think I'll do a part two and we'll read out of a couple of the books that I found on them. And then as far as this video, this is going to give a pretty good portion of information. It's slightly different from, well, not different, it's just a shorter video. And the book has, of course, a lot more detailed information, but it definitely kind of gives insight. So let's get started on it, guys. Just one moment.
Centuries before the glory of Rome and its unique people. The secrets of their world lie buried in the hidden cities of the Etruscans.
too. There was strong that they came ready-made Etruscans from the near Middle East, possibly from the area of central western Turkey.
Around 900 BC, went in Italy, eventually settling between the Arno River on the north and the Tiber River in the south. Etruria consisted of 12 city-states, which lasted about 500 years. Scholars argued the of Etruscan origins. Did they evolve from farmers who were? Did they migrate in ships from a far-off land, as purported by the 5th century? The Etruscans won a reputation for themselves in antiquity as being a uniquely religious people. In their exuberance for life, the concept tied to some higher calling, to supreme responsibility, and live within the cosmos. As they accepted the cycles of nature, they also expand of men, as well as that of their own civilization. Prophetically, they knew they wouldn't last. Tied in with their belief that the gods controlled destiny, the Etruscans were deeply involved with the.
In the Tomb of the Augurs, we actually see the Etruscan priests with the gesture of the hand brought to the head and looking upwards. Very likely they are looking to the flight of birds in
Prophecy was the aspect of Etruscan religion that was most readily integrated into Roman mysticism. It is due to the Romans adopting this ritual that knowledge of it has come down to us. In fact, it was a Roman priest who warned Caesar about the Ides of March, and yet Caesar, as his fate had been sealed. They were also known as a people with a taste for violence and barbarity. It is believed these stone channels carried blood during the high priest rituals of human sacrifice. Why did they do this? Scholars may only guess. 6th century BC, culturally sophisticated, politically. The city of Tarquinia was the crown jewel of Etruria.
And if you had come here in the 6th century, found not only a very prosperous and thriving city, but also at that time put the temples there, paved the forum, created what we might call the basis of Rome as a city.
The Etruscans also had wine almost as early as the Greeks. It's very hard to pin down the.
We're told by Greeks who were fond of being shocked by the Etruscans that they played music to just about all of their daily activities. For example, when they were kneading bread, they had the pipes going. When they were singing, they.
The slaves ranged from the musicians and dancers we see depicted in the tomb paintings to the cooks and servers and the anonymous multitudes. This class were not buried in the tombs, only their pictures. In some of the tombs, like this one in the Etruscan city of Tarquinia, walls were painted with scenes from the occupants' lives, as well as depictions of religious beliefs. Like many other
the Etruscans was a pleasant.
Etruscans must have by the depiction of sexuality, as exemplified by two paintings.
Archaic innocence, accepting life, knowing all about it, and feeling the meaning, a right from a moral meaning. Some actions the man-faced bull accepts calmly. Against other actions, he charges with lowered horns. It is not judgment. It is the sway of passionate action and reaction of the father of milk.
The span of the 6th century BC represented both the height and the beginning of the decline of Etruria. The world of the Etruscans, with its splendid royal and aristocratic life, began to crumble by the end of the 6th century. Roman historians paint a picture of Etruria in this period that is quite bleak. The undoing of the Etruscans, they said, was due to a lack of morality, exemplified by Lucretia.
The Romans told this as a kind of adjective, an irony of going too far in sexual excess.
The Romans were outraged. According to their historians, they unanimously agreed and ended Etruscan family. As a result, the Etruscans lost crucial control of the Tiber River, trading with southern Italy. They scrambled to hold onto their other trade routes, so crucial. The Etruscans strengthened their naval power through an alliance with Carthage against the Greeks, who at that time held the island of Syracuse, or what is known today as Sicily. But this tactic was in vain. The Etruscans suffered death and destruction in a disastrous naval defeat at the hands of the Greeks. For the Grecian warriors, it was sweet revenge. After years of humiliation on the high seas at the hands of Etruscan pirates, the Greeks. In the year 396 BC, Veii, the Etruscan city closest to Rome, was taken after a 10-year siege as Roman legions marched into the city. Their independence was their undoing. The League of 12 city-states should have banded together to stem the rising tide of Roman advances. But the members fell to bickering with one another, and thus never formed the kind of alliance necessary to hold the Romans back. One by one, the Etruscan cities came to Roman control. Rome conquered Tarquinia, the jewel of Etruria, in 351 BC, and then Cerveteri in 343 BC. The aristocracy on a large slave population. Ultimately, when the slaves finally revolted, the city-states were weakened by all the civil unrest. The Romans acted on a critical opportunity. With the adoption of the Etruscans into the Rome, their religion, customs, and language fell into disuse. They became Romanized and took on the more acceptable mode of communication, Latin. As the centuries passed, the Etruscans all but disappeared. Their legacy minimized. Brief inscriptions surviving the centuries offer a few insights. Though written in an alphabet mostly borrowed from the Greeks, the language itself has yet to be decoded. Their Bucero pottery, black with embossed details, has also defied duplication. Into the game, Etruscan competition only as spectators. That's because the games were usually played to the dead, ironically as entertainment at funerals.
The Roman historical tradition tells us that it was from these funeral games of the Etruscans that the Roman tradition of circuses and gladiators grew up. So for those who love their Etruscans, usually find this a negative side of their civilization, that blood was spilled on the occasion of a funeral, with boxing or with games in which someone is set upon by dogs.
A victor. Others were quite strange.
Always this way, stretching from the Po Valley to the Tiber River. The Etruscan civilization thrived for centuries, rivaled the sophisticated classical trading acumen of Persia and the wealth of Egypt. In this video, we will tell you the story of Italy and the monumental cultural impact they had on the young Roman Republic. Blinkist for Yuval Harari's 21 to the full membership. In their early history, the Romans referred to the strange family covers most of the globe. But in the Iron Age, it would have been a relatively new arrival in Europe, with the Greeks, Italics and Celts all being descended from a common ancestor that likely migrated out of the Caucasian mountains between the 3rd to 1st millennium BC. The Etruscan language, however, is not Indo-European, making it not inhabited Europe long, potentially making them Italy's earliest known people. Whatever their origin may be, we can trace the Etruscans' archaeological presence in Italy as 1200 BC, around the same time the Trojan War supposedly took place. Little is known about Etruscans this far back, but with weapons forged from bronze, they came to dominate central western Italy. They built their villages on naturally defensible plateaus, constructing houses of thatch and mud while subsisting off farming, herding, and forestry. They cremated their dead in primitive burial sites and saw the first Italic peoples enter into the peninsula, but the forebears of the Romans had centuries before their time in the sun would come, and the Proto-Etruscans retained their territorial and cultural integrity in the face of this migration. By the 9th century, entered what is known as the Villanovan phase of their history. Ancient Tuscany was abundant in natural resources, and the Etruscans grew prosperous, mining the abundant copper and iron deposits in their lands. Small hill villages began coming into line, and population Quinia and Vulca noticeably more complex, as observed through their architecture, which now features ornately decorated homes interred in dedicated necropolises, the richest of which were home to graves bearing ritualistically elaborate weapons, shields, and armor made of bronze and iron. The grave luxury Etruscan pottery, sculpture, and art took on a distinctively Eastern style, while the Etruscan elites adapted courtly rituals that emphasized pomp and ceremony, especially rites involving wine, a drink. Most important system through which we retain the only documentation of their mysterious today. This era also presided of Etruscan society, as their towns bloomed into cities with paved roads and aqueducts built amongst hallowed tombs, austere temples, and luxury villas inspired by Hellenic design. Warriors evolved into professional armies. The Etruscans expanded their territory, coming to dominate other Latin neighbors, including a certain little backwater town called Rome.
I think I went back.
Much like the ancient Greeks, the city-state was the main political unit in Etruria, with a single city forming a nucleus of control surrounding rural territory. The cities were often in fierce competition with one another, and war between them was not uncommon. With that said, the 100 consisted of the 12 most powerful city-states, called the League of 12 Peoples. While this enables the Etruscans to regulate each such.
Okay, just to verify, guys, I think I went back too far. Do you guys remember seeing this? I've watched this video a couple of times because there's like 3 other things I want to get into. This is just kind of showing you guys the maritime, and how this came into effect. The seamen, you hear them keep talking about the seamen. What are the seamen? That is all part of maritime law and everything with, taking over all these things. The Phoenicians, yes, this is part of Phoenicians, Janelle. They are the same line, they're coming from the same place. Then they conquered, like, I think, Greeks after that. I want to get into this next video, but yeah, that's interesting. I'll put the video in the and if you guys want to watch that later, finish. Get a better look of
centuries before the glory of Rome.
That's not it. All right, here it is. I found it. There's 2. They're both pretty short. This one I think is about 10 or 15 minutes. Let me double check. Yeah, 15 minutes. And yeah. We're gonna get into it. What's going on? Yes, Janelle. Peace. I see. Says, let's see. About to get this going. Still having some internet issues. I do not know why. I just don't.
All too often, we remember the Roman peace which followed. This is an issue for understanding history properly, since the vast majority of the people lived their lives away from that bleeding edge. After all, was the stability of the Roman Empire, which was its greatest claim to fame. In this episode, we'll be kicking off a series on law and order in ancient Rome by starting off with its very foundations, law. I spend a lot of time reading history books to make these documentaries, yet I still find myself I'm sure in your be tough to find the time to explore as many books as you'd like. Blinkist 1,000 in just minutes for help subjects you'd never otherwise get to, or for making a short list of the books you definitely want to read. Claims that the people began their first activities without any fixed laws and without any fixed rights. All things were ruled despotically by kings. While this assessment holds some merit, we should at the same time realize that no society is ever laws of their members. In these early days, this occurred across the basic levels of society. The lowest of these tiers was the family group. At this level, the father, or paterfamilias, held the most power. Above this level would be the interactions between neighbors. Their actions were governed by customary laws, which had arisen organically to deal with common issues like marriage, property, theft, and murder. Forming these ideas would have been religious beliefs, which were regulated by the priesthood. Next level up would have been the ruling class of the patricians, with the king at their head. Their laws were commonly delivered in the form of royal decrees to the city, or in the form of rulings passed in judgment of petitioners to the king's court. The main takeaway here is that while yes, there were indeed known as the plebeians, were literally second-class citizens. They were unable to appeal legal judgment in the patrician class. From the perspective of the majority of the population, indeed a despotic time. Things were chased from Rome. The plebeians saw a chance to have, yet the elite were in no mood to share power within the republic government, and so a socio-political struggle that would run the course of history for centuries to come. To break the initial status quo, the furious plebeians staged a massive public protest whereby they abandoned the city of Rome and refusing to take arms. Enemy armies closed in. This finally forced the patricians to take some concessions. As a result, a new set of government magistrates were formed, the tribunes of the plebs. They were positions exclusively limited to the plebeian class, with the power to propose legislation, intervene in legal matters, and veto the actions of other magistrates. The common people finally had a say in the law. Their next move would be to tackle its arbitrary nature by demanding the law be physically written down. Thus, the 12 tables written. They were not a constitution as we would understand today, but rather just a compilation of some existing customary law, most of which reflected the rural aspects of the people it governed. As an example, you can find passages specifying the width of roads, punishment for grazing in someone else's fields, and even death penalties for singing abusive songs about others. These eclectic laws were originally carved on wooden tablets and set up for public display. Eventually, they were upgraded to bronze for the eminence, and, for hundreds of years, Romans would memorize their contents. While certainly an achievement, the 12 tables were quickly altered, added to, by new laws throughout the history of the Republic. With this in mind, let's now turn to see how the laws themselves were initially formed in the popular assembly. There were three different types of these: the Centurion Assembly for high elections and military affairs, for lower elect, the Plebeian Assembly for matters that affected only the last. Initially, laws, after a consultation with the Senate, were proposed to the people, who would have time to meet among themselves to discuss it. On the day when the tribal assembly was called, the adult male citizens would meet together. No discussion was held at this meeting, only the vote. Individual votes tallied within groups of people, which in turn got to vote. The tribal assembly, there were 30 rural tribes, and only urban tribes for the poorer and more numerous city dwellers. The end result was a lopsided vote, whereby the smaller number of patricians maintained control. After a law was passed, a marble tablet placed in Rome treasury. The text contains the sponsor, the votes in support, and the date of adoption. 2. Main text of the law, which was broken into sections, and 3. The penalties for breaking the law. So what kinds of laws were being passed? Well, you had all kinds of things that you might encounter today. There were private laws for individuals, families, businesses, small groups. This included things like marriage, divorce, succession, contract, property rights. There were also laws for and crime. Then it did collapse or were simply outdated. In addition, as Rome's borders grew, were not covered by early laws. And many Roman law would expand to deal with was the conflict of the orders, whereby the plebeian city dwellers were constantly fighting. Grecia was adopted, declaring resolutions passed friction, which would prove the Senate and the assemblies seem to have worked quite well together. As a general principle, the Senate did not interfere in assembly affairs, and in return, the people granted all the mid 2nd century BC due to a variety of factors, including the stage. First, agreements were handled using the law and in accordance with the mos maiorum, the way of the ancestors. But as tensions mounted, law an edge, bit by political norms frayed, until the law itself which dealt with land undermining one another. This tit-for-tat gridlock ultimately led to seek solutions outside of the Republic. Before we get there, I didn't mention the experts who emerged to deal with the increasing complexity and technicality of Roman law. Their efforts were significant in the first time that individuals. They thoroughly precedent and the actual text of the laws in order to act as premier legal specialists. In a world where there was no one place to questions, how for a true legal community. People would reject the was achieved by restoring the traditional offices, public assemblies, and voting. They granted legal powers. In this way, dictator were actually wielded the same, if not more, power. Thus, Augustus reigned humbly as the princeps, or the first man in the role of
Pause it for a quick second so that we can see the rest of it without it kicking me out. It's mad because I got books up basically, to be honest. I'm really good at this. So give me a second, guys. I'm gonna let it load for a second because now me knock out all my other windows too. So hold on a second. Let's see. I think we're about ready to go. Load up with a little bit of juice, and we're about to get into it.
consolidated is difficult to disperse, and the Roman transition to empire. So how did the law work in this era? For starters, new changes were not directly led imperial edicts, all of which could overlap and contradict. In addition, you had all the complexities of dealing with examine magisterial edicts, all of which could overlap and contradict. In addition, you had all the complexities of dealing with non-citizen subjects of the empire and foreigners, a category of law which we've barely even touched on. As you can imagine, it was quite the mess. This is where the jurists made a triumphant return to bring some semblance of order to the law. But of course, they would not be allowed to do so without some mechanism of imperial control. And this had created something called the power of speaking with the authority of the princeps, which he issued to a handful of the most prominent. Jurists were allowed to continue practicing, and judges were not explicitly required to follow the decision of the chosen jurists. but in practice, it was nearly impossible for a judge to ignore the writ of the emperor. In the case of a disagreement between two ordained jurists, a judge would choose the more relevant opinion. Over time, these jurists took on a more formal role in the legal process and evolved into something that we would recognize today as lawyers. They gave counsel to magistrates, officials, and judges. They assisted civilians in drafting legal documents and transactions. They advised litigants, argued cases in court, and were professional teachers of the law, which had become a formalized part of the Roman education system. Perhaps most important of all, they wrote extensive treatises itself. Their work was fundamental to prudence and played a key part in the management of the empire. In fact, many of these works would be captured in the famous Code of Justinian of the 6th century AD. Ultimately, Roman law, honed over the centuries, would prove foundational to the success of not only their civilization, but the many civilizations which followed in their footsteps. Even today, we can find many echoes of Roman law in the civil law and common law systems practiced across the world, or in the Latin terms used to describe all sorts of legal principles. There is so much more to discuss when it comes to law and order in the ancient world, but today this is where we will end our episode. Stay tuned for more fascinating videos. A huge thanks to all of our patrons who help fund this channel, and all the researchers, writers, and artists who made this video possible.
Hold on a second, guys. I'm gonna pull this book back up in a minute. I had to close my window down because it kept trying to put me out. But real quick, let me see. Okay, this is one more short one. I can catch a break today. Let's see what's going on. I got to get the energy pop on there. Something's not right. Let me see.
Roman system and common law versus statutes in the Roman system. This lecture is part of a series with Professor Epstein on how this ancient legal system can crucial insights about modern problems. Professor Epstein is one of the most prominent legal. He is the inaugural Lawrence A. Tisch Professor of Law at NYU, Senior Fellow at the institution, and Professor of Law Emeritus and a Senior Levy of Chicago. The Federalist Society takes no position.
Historic changes, like becoming an empire. How did that affect the legal system?
What happens is when you're trying to figure out the way in which Roman evolves, it's a very long period of time. And probably the single most important break is the end of the Republic after the death of Caesar and the rise of Augustus, which spanned basically just before and just after the birth of Christ. And how does this influence things? And the answer is there are two ways in which you can look at this. One of them is a public law matter, and the other is as a private law matter. If you're a law matter, the changes are very long. Res publica means that those affairs, the word race could either mean a tangible thing or a set of social affairs, which belong to the public, should be decided by the public as large. These classes, one, the Senate, which is a term we use for our upper house to this day, and then to the Publicians, which become the House of Representatives. And represents ways, there would be a clash and a set of checks and balances between these two parties so that you could be reasonably confident that no one person could take charge. In addition, much of Rome was governed by two councils, not one. And so what you did is one executive could give a check against the other. And what you saw was a political system which obviously would have many weaknesses in practice, but it was alert to the dangers of arbitrary power. And when you get to the empire, all of that starts to disappear. And you get the maxim about, quote, Quinkeby Pluckwit, that I guess with Gorham Hobbit, one big cheese can call all the shots. And so Roman public law ceases to be a very interesting subject if the only thing that it deals with is the. And therefore, when you do Roman in the constitutional history is done essentially Roman historian, and Roman private law is done by another group of scholars who are essentially lawyers. And I've attended many a meeting with classicists, and their knowledge of Roman law on the private side is relatively weak because they're not fully trained in a legal system. My knowledge that I can't tell you or whether this particular empire went to the left or went to the right, this one was honest, this one was corrupt, and so forth. So they're sensible complement. When it comes to the private law, the continuity across the Republican and the Empire is almost complete. If you go back and you start to read Gaius and so forth, what he does is he basically identifies two classes of scholars who differ from one another, the Sabinians and the Procleans, one of them being more concerned with substance and the other being more concerned with form as a way of organizing situations. And so what he then presents essentially 20 or 30 disputes between the two schools on how it is these scholars would resolve problems. The first thing you realize when you see a school dispute is if this thing has not been resolved authoritatively, it means that it's probably a very low probability event of occurrence, and that's the academic predilection to a hard problem that never occurs instead of the routine problem that occurs every day. Lawyers should be forgiven that, but when any client, they don't want you to tell them how to deal with a complicated case where the recordation system gets messed up and you don't know what priorities are. They want you to be able to put together a system where the title doesn't get messed up so they don't have to spend a fortune to sort these particular cases out. And that was also true in Roman time. And these guys, Proculus and Sabinius, are Republican figures. And what they do is all this stuff starts to carry over and it's elaborated in that particular time. And if you're trying to figure out what's going on, there's always a natural evolution over time between these periods, which Gaius is pretty scrupulous to talk about. Get to Gaius, and certainly a little bit, many of the formal distinctions between different kinds of contracts tend to erode relative to what they were in earlier periods. It is a common feature in early legal systems which are unsecure of themselves to have an excess of formality, and then as systems are more self-confident to soften it a little bit, not absolutely, but at least a little bit, and you start to see that. But essentially what happens is when you do Roman private law, you spend some time on the evolution of legal doctrines, but you don't pinpoint it a tie to the political changes in the larger system. My late colleague at the University of Chicago and my tutor in property law at Oxford back in 1965, Brian Simpson, was a great legal historian. And what he constantly reminded me of, even if you're of some, whether in Roman law or early common law, first think of the way in which the system is put together internally, issues, and only pretty good evidence of a large political struggle, you bring it, talk about it. And that's generally speaking a pretty wise piece of advice. You can obviously find cases where private law issues become public law issues. And so, for example, in the Coke-Ellesmere dispute that took place in about 1616, the courts of equity were associated with royal power. The common law courts were opposed to it. And in effect, when there was dangers of the crown overreaching, the difference between these two legal systems was not just a question of whether you get damages or injunction in a private lawsuit. It was a question as to whether or not, when you looked at this thing, one party was going to be able to control over the other. And certainly, although it's harder to isolate these events in Roman law, you would definitely get these kinds of political struggles that occurred there as well. in the materials that I tend to teach, dealing with persons, property, contracts, and torts, there's almost never a hint of anything of that sort in these things. Private stuff tends to dominate, and this public overlay tends to be put to one side. If I were a constitutional historian of some form or another, I think I could find cases where it dated. I will let the historians present it to me. But if you're trying to teach Roman private law to individuals, and you know that 99% of it is going to be based upon ordinary private law principles, which include the interpretation of statutes that supplement and vary the common law rules that are made by judges into high politics too soon. You want to put it off until an appropriate occasion takes place. So the continuity between the time of the 12 tables and the time of Justinian, 1,000 years, on the private law subject, there's increasing sophistication. And they're major statutes. But again, the Lex Aquilia, which is thought to be the single most important statute on the law of torts, is adopted roughly around 287 BC in the Republic, and they're construing it for all it's worth 400 years later. Obviously, the change between the Republic and the Empire does not have much to do with what's going on in that very difficult statutory construction.
So the legal system primarily dealt with private rather than public law? How would the Romans have defined the rule of law?
When you start looking at the public and the private law sections, one of the things that you're always going to ask is, how does this resonate with respect to a modern theme, which is sounded in John Madison, and to which every working politician today has instantaneous appeal, which is the rule of law. And the answer is, if you're going back to earlier times, the rule of law was not very much on the table as a legal doctrine, because the principle of absolute authority meant that the emperor can do what he wants. That meant that he can do it by way of law. So the usual requirements of the rule of law, that there be general principles known in advance, understandable by the public, administered by a group of individuals free of bias and prejudice, allowing all parties to be heard, was understood in Roman law. And in fact, one of the nice things about it is that the major max that you have in here, nemo iudex in causa sua, nobody should be a judge in his own cause, or audi alteram partem, always hear the other side, are in Latin. And if you did administrative law under the English side, they would call these this. In the American area, we tend to call them principles of due process, based upon the due process clauses that are found in both 14th, nor shall any person be deprived of life, liberty, or property without due process of law, binding both the federal under the Fifth Amendment and the Fourth. And these are extremely valuable principles, because if you do not have principles of procedural due process, the substantive rules will not survive. So this is a way in which to think about the issue. If you had an impartial presentation of the evidence, then the case would come out, say, 50-50. But if you've got a biased set of rules, it's going to be coming out 2-1 on one side. So what does this mean? Well, think of this as a dice. And if it's 50 and you flip it, it's going to be either 1, 2, or 3, one side, 4, 5, or 6, the other. But if it turns out that you're talking 2-1, now it's 1 or 2 on one side, 3, 4, 5, 6. Essentially what happens is one of those little pips goes over the other side. That's roughly like taking 1/6 property of one party and giving it to the other. That everybody who's ever dealt with procedural due process knows that bias becomes a way in which you the odds of deliberation coming out correctly from the true estimate to this cooked up. And how does that differ from a substantive command which says, thou shalt not take 1/6 of the property of somebody else in litigation? So substantive due process and procedural due process sound in any legal discipline. But when you start putting rules which survive to this very day, it becomes clear that there's an intimate connection as between two of these things.
Speaking of odds being stacked in favor of the Roman world, the emperor seems like the most likely person to get the benefit of that. How did that affect public and private legal arrangements?
And so therefore, I mean, this particular point of public law adjudication, how does it get placed in the Roman law system? The way in which we deal with this as a Romanist or as a modernist is we create what are known as default presumptions. And what does it mean? Well, it means that the emperor can do anything that he or she darn well pleases at any particular time. But if it turns out that the emperor is silent on a particular issue, then we will assume that the emperor has agreed to be bound by the principles of natural law, because as a great and benevolent leader who's concerned only with the welfare of his people, perhaps a fiction, but perhaps not, these are the rules that he would adopt. And so you then put these rules into place as a matter of practice, and the strategy that you try to develop is to keep them in place enough time so that it becomes extremely very difficult for the empire to start to change these things, the public confidence in the way in which he's going. And if he tries to do it in a particular case, it looks as though it's arbitrary and capricious. And so if you have the default terms correctly set, you try to make them sticky, to use the modern terms, and so therefore they start to bind. And this technique is still used to this very same day in modern times in connection with property rights. The biggest question that you often have is the same one you talked about with provincial lands, is you've got Aboriginal people, whether it be in Australia, Hawaii, New Zealand, South Africa, and so forth, who seem to enjoy a series of possessory rights. And then the question is, even if the crown has the absolute power or the government to remove them, did they exercise that power? Because if not, then the judges are going to assume that the natural principles of first possession, coupled with the various rules on fairness, being right to be heard before an impartial judge, govern the case so they could start to stabilize it. So there is this very, very powerful influence of these Roman law principles. And note, these are procedural principles and not substantive principles at the time. But then tied up with the substance, because the Roman rule maxim prior in time is high, essentially will favor incumbents, i.e., Aboriginal and Native peoples, over the newcomers coming in there, which now creates a genuine kind of tension. And how you get rid of it is very interesting. One of the things that was done, for example, in John Locke, he gets very kind of obscure on this issue. And it turns out that you acquire possession of an acorn the moment you pick it. You acquire possession of the land the moment you cultivate it. Maybe. That's obviously very inconsistent conceptions. Why does he do that? You require cultivation and you have a series of Indian tribes who are hunted together, then their possession doesn't count. What you mentioned happened. And it turns out that Locke is wrong on the land. Occupatio, which is the Romans, just means that you marked it off from require labor in the land. If you go and you look at Locke in the 5th chapter of A Property in the 2nd Treatise of Government, the word occupatio never occurs in that particular chapter, which means that he's bollocks the Roman law and the English common law, and has done so in a way with the labor theory of value, which makes him sound sometimes like a libertarian and sometimes like an early precursor of Karl Marx. You put occupatio back in place, meaning it's just a demarcation, and the whole system completely turned over, and there is not a slightest hint of Marxism in the common law or in the Roman. And sensibly read it. If a guy doesn't get something right, it turns out if he's that info, the error will span at this particular point 3 centuries plus.
Can you talk a bit more about how the Roman legal system adapted for governance as the empire expanded?
I've already talked a bit about the temporal element in dealing with these systems, starting with the Republic and moving forward, roughly speaking, to the empire. But there's another transition of equal importance in that transition, which is what happens. You start to leave native Rome on the one hand and start to acquire by conquest properties elsewhere. And this presents very serious problems of judicial and legal administration to handle. And essentially, unless you have a more or less honest system and governance, you cannot rule for a very long period of time. You will face massive insurrections, some of which will turn out to be successful, and the others which will bleed to death, which is what happened towards the end of the Roman Empire. So how do we start to deal with this? And one of the problems I've already discussed, which is when you're trying to figure out who owns the emperor, the people have title, what you have to do is to create some kind of substructure of land which will allow indigenous people to continue to live in their own territories and to be able to trade land with one another and so forth, to farm it and so on. And for that, what you have to do is to treat your titles a bit aloof. This is not all that different from the situation that happens under feudalism, where when William the Conqueror comes to England, there are lots of local people around, and what he decides to do is to create a feudal system in which, in order to prop himself up as sovereign, what he does is he enfios or conveys land to his various henchmen, who take large chunks of land and then owe him obligation, and they do the same thing to people coming down. And in the early stages, in both the Roman and the today, when you're dealing with, say, a Chinese system, which is private property, trying to figure out how to separate sovereignty becomes the center to create this subordinate. What you have to do is have to be perfectly consistent rights, and then you have a regulation which explicitly asks when you could regulate, when you can confiscate through eminent domain powers and forth, but that lies in the future from the system. And what we don't know about Roman law is how this thing actually played out in different territories. Gaius gives you 10 lines on the whole subject. There's nothing whatsoever about this by the time you get to Justinian, because the provincial gap between the original Romanist and the territories was ended when everybody became a Roman citizen several hundred years before Justinian worked. The theory was that we're going to protect our empire and we have second-class people resolve it. It's not going to work very well, so citizenship accordingly. So that's one area. The second area, which is of great importance, is what do you do with commercial transactions? Commercial transactions generally are not transactions in land. They're trading relationships of spices from one location for finished products in another location, and the contract that one has to deal with. And if you're dealing with, they tend very simple transaction in the sense that ownership of this particular thing, and you give me a price. And since we're going to be 4,000 miles apart or 200 miles apart when it all ends, the idea that I sell you something with some residual rights in the thing that I sold doesn't make any sense. If I lease property to restrict the way in which you could use it, because I've got nearby property and I have the right to get this property back after, and if you can do whatever you want with the property, it's going to prejudice me, so that those relationships are not what we call clean deals. Those relationships have constantly continuing obligation. When you're strangers, what you realize is that every people has its own kind of formalities with respect to these transactions. They can be a stipulation. I hereby agree to sell you this for X price. And the other guy says, I hereby agree to buy. But the other fellows don't know from this particular situation, and particularly well, they have their own formulas. Maybe you need witnesses. Maybe you need writings of some sort or another. So the tendency is to just eliminate all the formalities that they created among all of these. So by the time you get to the formulation in Gaius, essentially sale is listed as the first and probably most important of the consensual promises, a contract, and the only thing that it requires is an agreement between the parties about the price to be paid, and then you have to fill in the rest of the gap by terms, default provisions, and so forth. And that was the way the world was organized.
Was there a role for the common?
All right, so the last portion of that was about 11 minutes long. It was going to go into a little more information, but not as clear as this particular video is on the same thing. So I'm going to show you guys this last video. I think it's about 9 minutes or so. And that will be that. So let's get into that. Where did it go? Yeah. I'll do this one first because this one's a short. Hold on a second. The other one actually is 18 minutes long. I'm sorry. This one is only 2 minutes long, so I'm going to show this one.
Getting the private law right is important, not only for inventions that crop in if you don't get the system properly organized, you will never think about the public law in this way. It's a private law issue. As you deal with the cases of public necessity and so forth, it becomes a public law issue. And all of a sudden, the same rules of compensation that you have in the private law become the rules of just compensation that you have under the Fifth Amendment to the Constitution. And the large difference between myself as a constitutional lawyer, the Supreme Court, lower court judges, and most academics, I came to constitutional law out of Roman law. And they come to constitutional law out of the Constitution, and they don't worry so much about this substructure. And my own view is that just never works. All of the public law is based upon these private law conceptions, private property, freedom, and so forth. Contract are all built into the Constitution. They're all short words with immense histories, just the way the word in English word with an immense history, just the way the word causation looks to be real simple until you break it down into its 52 different components. And public law shares those kinds of difficulties. And at some point, what I hope to be able to do is to explain the way the carryover from the public to private law works and forces you to make a fundamental review of those public law conceptions.
It's moving slow. Okay. It's moving slow.
On particular legal or public policy issues. All expressions of opinion are those of the speaker.
What rights does an individual have under the natural law?
The question about natural law applies not only to the issue of how you acquire, but also with the general autonomy principle. Using the sort of was a rarity in virtually every legal system until mid to the late part of the 19th, which is namely that every human being is a separate legal person who has any effort essentially to limit the ability of an individual to transact on himself had to be done under a guardianship type of arrangement, where the keynote was that the arrangement was put into place for the protection and benefit of an individual that lacked full capacity, rather than a slavery or an ownership type relationship where the subordination was made for the benefit of the party who did the subordination. This is not an easy concept as you might think to otherwise do. So it's worth kind of breaking it out into a couple of different cases to see the way in which it's in the mature system. The most common case of this is, of course, parent against child. And at this particular point, it's quite clear that the parent has large fiduciary duties to the child in terms of nurture and upkeep. But it's not as though under these kinds of relationships that they don't have any rights to make sure that they themselves are able to survive. And so there's this very difficult balancing act, particularly in times of scarcity, as to how much resources should be devoted to the child and how much to the parent. If you give too much to the child and not enough to the parents, they may become sufficiently weakened so they can no longer protect child. If, on the other hand, you give rations that are too low, the child will die no matter how much protection is given. And so what you often develop is these kind of crisis situations in very adverse times where you actually almost have to let a child die because the parents, either everybody's going to die for child, or the parents stay alive, the child will die of exposure or starvation, and then the parents, if they can recover, can breed and start again. Everybody understands how awful and ugly these situations are and how important abundance is in order to eliminate these problems. Why is it that the legal system tends not to intervene in these cases? Also pretty clear. The genetic overlap between parents and child that I mentioned indicate that the parents themselves have a huge incentive to take care of the child because of the common pool of genes between them. And love between parents is essentially designed to secure cooperation in the protection of the child, so that generally speaking, it's very difficult for a legal system to intervene if what you're doing is you're making mistakes at the margin. So the review standard that's adopted virtually everywhere in one form or another is a standard of abuse or neglect. And abuse covers those cases where essentially you treat the child as a tool for the benefit of the parents. And neglect is a situation where even though you have the resources that might be able to care for a child, you choose to devote them to some other person. Given the biological incentives, both abuse and cultures, and at some times things are more difficult. Cinderella gives you on the who's more likely to be the natural parent, and so when they assume guardianship obligations, it's more likely that they will be breached than when it's natural parents, which explains why it is that everybody has at least an uneasy feeling about adoption, notwithstanding the fact that in many cases it turns out highly successful and something of a moral imperative to a child who can't survive. It's also instructive that you're dealing with these adoptions. Often the adopting person is not unrelated to the natural parents. They can be brothers or sisters or aunts or uncles or grandparents. And the reason why you have this is in earlier times, there was no that when parents would live through to see their children maturity, if in fact the normal Roman times, and indeed even after somewhere between 30 and 40 years, it's quite clear that you can have a parent who dies before the child has reached maturity and the ability to handle it. And so you have to put these kinds of relationships in place. The standard common law view was that these are natural obligations of parents to children. They come by virtue of the relationships. The abuse and neglect standard is when the statute comes in order to try to control the abuses that sometimes arise in these relationships.
What other sorts of relationships would be governed by these rules?
At the other end of the spectrum, people who are old and people who are senile and people who are insane. And again, you have a guardianship relationship upon them. Sometimes it's not natural love and affection that guides this. It may be a more commercial relationships of some kind of an institution and so forth. The same principle still on, but here in effect, you probably have to do more external monitoring because the natural bonds of love and affection are necessarily there. And all modern legal systems try to develop some kind of relationship to handle these things. When you teach, as I do, medical ethics, what you realize is the central assumption of market economy, which is into trans longer good. What you do is you face individuals who are having to deal with the most difficult decisions of their lives, life and death, when they're least able to handle them. Their capacities have diminished. Their judgment is often blurred. And so trying to figure out what substitute arrangements you start to put into place becomes a real challenge under these circumstances. You have advanced directives. You take a situation or another. These are problems that happen for all individuals. So when you start dealing with, quote, estate planning, which was the course 1868, you were worried about the transfer of large estates from one generation to another. We now tend to call this course elder care in many cases because the financial stuff will be very small percentage of the population, say 2 or 3%. On the other hand, the social arrangements on guardianship and competence are important to everybody so long as old age and frailty of judgment turns out to be an issue. So when we start to say that every natural person has full and independent rights, it's always understood that the ends of the guardianship arrangement are there. If you then go back to the earls under Rome, and that what you did is you had two very different kinds of relationships. Both are worth talking about in some detail. Would be the of children under the familial side, and the other turns out to be the question of the status of slaves, dealing with a society in which they do not have full competence. A distinctive Roman institution which did not survive, which applied only to private transactions, not to political life, was the arrangement in which the power was vested in patres and family, and it was a patrilineal system. It was a patrilineal system, and the basic rule of a mini emperor would in fact distribute the rights and within the family, subject to his own discretion. There may well have been an abuse or neglect, and so what goes for an old and doddering father, and you have two sons and one daughter, they're all underneath your power, which means that none of them can enter into contracts with third parties by themselves, but have to have your blessing in one form or another, which could create all awkwardness and tended to develop in kind of general agency rules so that they could transact in the market with the large, sometimes implicit blessing of the father. And this would go to the grandchildren. Now, when that one person dies, it turns out, let's say he had two sons, then each of them would become the head of his own family, subject to every father. They entered into a joint venture. And the Romans had this institution of partnership, which had this strange Latin term, "recto non cito," the less you know about it, the better, which meant, in effect, that you would treat them as though they were partners so that they could continue their relationship without the guy at the end. When the father had to take into account the abilities of the others and the needs of the others on an equal level of its own, relationships became those bona fide relationships. What this meant was that when you're making a decision on behalf of the group, you have to weight the utility and the inconvenience to the other party, equal that. And if everybody follows that principle, which they're likely to do since partnerships are chosen on the nature of trust, to get a higher level of performance and to benefit himself while harming the others. When we talk about partnership, we can see the way in which the rules are put into effect.
What about marriage? How does that change the dynamic?
Now, daughters are a different proposition altogether, because what happens is typically they are going to be married off. If you go back and you look at the Roman text, you'll see why the passive voice is appropriate. A romance was not considered to be the dominant features in these systems. They tended to be planned marriages, and often there was a property transaction moving in one direction or another, a dowry perhaps, which the woman would bring to the new family. And once she married, she was out from the control of her original father and fell into the family of her new husband. So essentially, marriage at that particular point was a combination of a reproductive arrangement and a property transfer arrangement, which is why emancipation, the rules on conveyance, was applied very systematically, as outlined in Gaius, in Book 1, dealing with this subject, as part of the system. And then she fell in with the other family. Now, why is it that you have to have the switch? If you think about it for a second, it's almost impossible to have a situation where a single person, the future and now present bride, is going to be subject to the control of two people who may have views that are inconsistent with one another. So ownership type arrangements, guardianship type arrangements, paternal type arrangements always turn out to and generally speaking, you do not want different controls because so much of what they do is. So it turns out that the wife goes over to the husband's side and leaves the control on the other hand. Now, what happens is as time starts to move on, we start to see the breakdown of these larger arrangements. And then the question is, what about the relationship between the husband and wife after the father is knocked down? Roman law and early English law were relatively egalitarian about that. Read John Locke, he talks about parental rights, not so much paternal rights. And so the mother and the husband seemed to have more or less parallel positions, and that was true under Roman law. But you then have to worry about the questions of property settlements on divorce. That's going to take place in every society, and who survived this kind of situation. And modern divorce lawyers deal with exactly things that the Romans give to everybody is don't try to get a good divorce settlement, try to stay married, because essentially divorce is a very expensive game. It's a bilateral monopoly game. I can only get a divorce from you. You can only get a divorce from me. There's no competitive market out there, so that if I don't like the terms you offer me on a divorce, then I go to somebody else. You can't. You are not married. So these arrangements turn out to be extremely difficult, and they require some degree of arbitration and control. And in the family setting, essentially what happens is you can slowly see the change from this large legal person comprehending many natural person to a situation where each natural person has his or her own rights. And this became a huge campaign issue. It involved on the private side the question of women towards own property in their own name. In the late 19th century in England and America and virtually everywhere else, married women's property acts of one kind create this sort of parity. The issue was actually not fully resolved in these systems until 1970. If you look at community property states in the American West, for example, the earlier version had the wife having equal rights to the property, but the husband having management and control responsibility, and the wife only having ability to check him. And then by Supreme Court decision and by statutory change, what seemed to be a dominant one-sided relationship became a relationship of essential parity, and that stays. Still lots of complications. People bring property to the marriage before they're married. They generate property. Trying to have different things is a mess. And so what happens is people then enter into prenuptial agreements, even for first marriages today, and certainly for second marriages today, where each party may be widowed and have children separately. And so they want to keep the two fortunes away. With the Roman stuff, you can see the whole thing is going to unfold.
What about slavery?
Now, on the slavery side of the situation, it's a little bit different. And essentially what happens is you should think of a slave as somebody over whom you have absolute ownership control. So a slave is somewhat different from an employee. A boss may be able to tell a person what to do while on the job, but that person can always have the right to quit. A specific performance that is an order for somebody to continue to work when they want to quit are unheard of. It's just too much this quasi kind of slavery system, and no court wants to be in the position where they have to oversee whether or not the employment relationship is done or isn't done correctly. All common law courts back off of this thing in employment, but slaves, there's no such thing as being outside the scope of employment. They are the owners of the wife are going to control. If they're the same owner, so much the better. It's also clear that any child born to a slave union is the property of the owner under these circumstances. So it's not just a question that slavery is justified by conquest. And the original justification was, well, we took you over, we could have shot you. You should be extremely happy about the fact that we're letting you live and we'll exploit you in this way. But it also applies to the offspring, notwithstanding the fact that they've done nothing except be born to this particular kind of couple. Well, how do you run an organization like this is not easy. And what you see is there are two kinds of relationships, one lost history and the other which is extremely important. The one that is lost to history has to deal with one kind or another because they're subject to short-term orders, but they don't have any formal relationships with third parties outside the businesses. So what goes on there essentially may be checked by some abuse or neglect statute, such as developed in the American South in order to counteract the worst abuses of slavery, to be sure highly imperfect. May have had something like this under Rome, but it was not the dominant feature.
Thank you for listening to this episode of the Number 86 lecture series. The spirit of debate of our founding fathers animates all of the Number 86 content. In
Man, I know it was going in and out. People left or, got bored with it, but there was a lot of information on that in there for you guys to just listen to, ponder upon, and do a little bit of research. I put in the chat for you guys to check out tort claims. That's number one. The next video I do about law will have a little more information, and we'll start going into some other things that'll show you just a different state of mind and the state of being, and coming to self and knowing how to, basically be able to be in tune with reality, like we always talk about. All right, guys, peace, love, blessings, and hope you enjoyed it.